Okay, Amendment 5 is a bit more complicated than what we have been doing. Uh, Not because it's hard to understand, there's just been more to it. There have been more lawsuits that have relied upon this particular amendment. There's just more meat to it than um, what we've studied. So we're gonna do our best to get through this, um, and it'll be fine. So Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in the actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So there's a lot here and a lot to unpack. So let's get started. So the grand jury indictment is the first thing. The Fifth Amendment has 3 clauses in it pertaining to criminal procedure. So the grand jury indictment is the first of these. It requires that felony offenses in federal court be charged by grand jury indictment. And what this is, a grand jury is just a little bit bigger than a regular jury. It has a fancy name. That's about it. It's a panel of citizens. They hear evidence that the prosecutor is against the accused and decides if an indictment should be filed against them. So there's no guilty, there's no not guilty. They're not hearing evidence from the defense. They're just hearing evidence from the prosecuting officer, whoever that might be, and making a recommendation on if something should go forward. So it's one of only a few provisions in the entire Bill of Rights that the Supreme Court has not held to apply to the states through the Due Process Clause of the 14th Amendment. And that the court has been reluctant to apply a grand jury requirement to the states is unsurprising. The origins of the grand jury go back to Magna Carta, but the U.S. is the only country on earth that still uses these things today. Half the states provide for grand juries, aside from the federal government, though in many of these there exist other ways of filing formal charges, such as a prosecutorial information followed by an adversarial preliminary hearing before a judge. So, as early as 1884, the Supreme Court held that a grand jury is not a fundamental requirement of due process. And Justice Holmes' lone dissent has only ever been joined by Justice Douglas in the intervening years, that it is a fundamental requirement of due process. It really isn't. We've had some recent scholarship that has upset the previous understanding about these grand juries, that the grand jury was, from its invention, thought of as a good thing because it was not only a sword with which you could accuse individuals of crime, but also a shield against oppressive or arbitrary authority. A shield because the grand jury could say, no, I don't think this ought to go forward into a criminal matter proceeding. So in its very early incarnation in England, the grand jury was fundamentally an instrument of the crown that forced unpaid citizens to help enforce the king's law. There wasn't really a choice in the matter. If the king wanted you guilty, you'd be found guilty. So over the centuries, the idea of a citizen check on the royal prerogative. The royal prerogative is just, actually, it's what I wrote my master's thesis on. It's what the king or queen in any country can still do. It's the residual power left over that hasn't been codified into the laws of England or Spain or Luxembourg or Denmark. So a check on this power, and the power was much greater back then, it's diminished over time, has become more valued. So by the time the framing of our Constitution came around, both the grand jury, which are oftentimes composed of maybe 24 citizens, and the petite jury, which is just the regular jury, which could be as few as 6 citizens, were understood in both Britain and the colonies, meaning us. We were colonies at the time we're talking about, to be important bulwarks of freedom from tyranny. So few in the modern era would really say that. The former chief judge of the New York Court of Appeals, which is the highest court in New York, famously remarked in recent years that because prosecutors, again, agents of the executive branch, agents of the king being substituted in today's day and age by the governor, by the president, control what information a grand jury hears. Any grand jury today would, if requested, indict a ham sandwich. Now, students in the past have laughed at this quote, but it's really true. If you only ever say, you have someone you've never met who you're going to meet, and you've heard only things about how from your family about how much they hate you, about how terrible they think you are, how you're a lazy slob, how you're good for nothing, how they're going to beat you up when they see you, and your family was the only one feeding you that information, and you weren't hearing anything from anybody else, what would you think? Well, you'd think if person X came through the door, they were going to take a swing at you and start cussing you out, right? And maybe that isn't the case. Maybe if person X came in to talk to you, I'm just using a hypothetical, and talk to you, you'd find out they were really nice and really excited to meet you. And your family pulled a mean trick on you for some reason. But that's what that means. Just because you can make someone or something or some event seem really twisted out of context. So that's the indict a ham sandwich remark. So the greatest advantage these grand juries now provide is allowing the prosecutor to use the grand jury as kind of a focus group and learn about what evidence or witnesses are really especially convincing or unconvincing. And these things, they're here to stay, like it or not. It's written too deeply into the Fifth Amendment, the institution of the grand jury, to be very clearly and arbitrarily interpreted away. It's something we've got, and is something that's going to be part of the judicial process. All right, so double jeopardy is the second procedural protection. This should be familiar to most of you. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So the clause's core purpose is straightforward: to prohibit the government from forcing a person to undergo repeated trials for the same crime. So my wife, say, gets very mad at me. She's been in quarantine with me now for too long, over a month, I think. She doesn't think I'm pulling my weight. In a moment of madness, she runs in and stabs me through the heart. Okay, she gets put on trial because I show up dead, and it's clearly not something I did to myself. So they put her on trial. There are no witnesses. There's room for doubt. Oh, a strange man broke in, and before I could do anything to warn him, John was stabbed. They let her out, but later, and they give her a not guilty verdict, and she's free to go. But later on, maybe when they're doing some sort of autopsy or whatever on me, they find her fingerprints, or they dust the knife for fingerprints or whatever it is. They might do. I don't know why they wouldn't have done that before they put her on trial. But they find fingerprints on her. Well, they've already declared her innocent of my murder. They can't put her back on trial. Now, there are some unless things that go along with that, but we'll get to it in a minute. But very generally speaking. So Justice Black explains in a very oft-quoted passage in Green versus United States, the underlying idea is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. And that's really what double jeopardy is. Back with Magna Carta, back when King John was kicking around, the state put you on trial and would put you on trial again and put you on trial again until it got the conviction that it wanted. And the clause here has really given birth to some very complex jurisprudence. The current rule set forth in Christ versus Bretz and other cases is that jeopardy begins or attaches in a jury trial when the jury is impaneled and sworn in. So let's stick with my murder. So if my wife enters the courtroom and says to her lawyer very loudly, well, I killed John anyway, something like that, she's not protected. She just confessed in front of a courtroom full of witnesses. There's no protection. There's no double jeopardy. It hasn't attached. If the jury, however, is sworn in and impaneled, meaning brought together and sworn in and all that, and she maybe whispers it to her lawyer, and maybe a person sitting a couple feet away hears some of it, well, that's a different story. That wouldn't necessarily be considered a confession. So much of the double jeopardy jurisprudence really looks at circumstances in which reprosecution is either permitted or barred after jeopardy is attached. So one common situation really where this question comes up is when the government seeks a retrial after a mistrial. A retrial after a mistrial. And a mistrial is, will this be on the final marker? Yeah, definitely. I'm highlighting it. A trial terminated before a final judgment is reached. So if the defendant consented to the mistrial, retrial is permitted. So a mistrial is a trial terminated before a final judgment is reached. And the mistrial could be for any reason. Oh my God, the building's on fire. We need to evacuate in the middle of a trial. Oh my God, the room is flooding. The defense's legal team happens to be related to the prosecuting officer. Any sort of reason. The judge is the defendant's second cousin. Mistrial. So an early Supreme Court case here, U.S. versus Perez, established that even without consent, the defendant may be retried as long as declaring a mistrial was a manifest necessity. So like maybe, oh my God, the building's on fire. It's going up in flames. We need to evacuate. Well, that would be a pretty manifest necessity. You need to get out of the building to save life and limb. So you're going to get a mistrial there, or a retrial, whether you want to or not. So in Perez here, the manifest necessity was a hung jury, meaning a jury that could not agree upon a verdict. In fact, this would probably be on the final as well. Sometimes it is, sometimes it isn't. But, do you really want to take the chance of not writing this down and then it is on the final? If I was a student, I wouldn't. So while the term necessity might imply a nearly impossible burden for a retrial, the Supreme Court's actually been pretty generous in recognizing these circumstances. On the other hand, retrial isn't permitted after an acquittal, meaning finding that the defendant is not guilty. Would probably know what an acquittal is too. So there's more to it, but this is really the gist of the clause. I'm not teaching you pre-law here, so privilege against self-incrimination. So the third procedural protection in Amendment 5 is the right not to be compelled in any criminal case to be a witness against oneself. So I would probably also know, if I were you, these procedural protections and what they're called, the privilege against self-incrimination. So the Supreme Court has affirmed many times the understanding of these words. The defendant in a criminal case cannot be compelled to testify. That is, she or he can't be called to the stand and thereafter be held in contempt of court, usually leading to an immediate imprisonment if you're held in contempt of court. That's not a good thing to be. If she refuses to answer questions relevant to the charges against her. Now, that's a problem in the legal system early on that they had to overcome. So over the years, the courts read many additional rights into these words, both inside and outside the courtroom. Silence usually is taken as an affirmation of guilt. If I said to you, "Did you cheat on the exam?" and there was a long few moments of silence and your eyes went down to the floor and you shuffled your feet a little bit. This has happened in the past in some of my classes. Well, how would I interpret that as a reasonable thinking being? Well, you probably cheated. But we're not in a courtroom. There should be additional procedural protections for you. Silence should not be a presumption of guilt, even though that's the most natural human thing. It's really very natural to think that if someone won't answer a question or ducks an answer, well, they might have done it, whatever it is. So in Griffin versus California, the court struck down a California rule of evidence that allowed the jury in a criminal case to consider as evidence of guilt the defendant's failure to testify. So his silence in the face of evidence the prosecution had introduced against him. So that tossed that out. The reasoning was, and this is very important, very, very, very important to know. If the jury could draw a negative inference from the defendant's silence, this could induce a defendant who preferred not to testify, and you should have that right in a courtroom, to decide nonetheless to take the stand, at least where the defendant thought his testimony would be less damaging than his complete silence. So that's the reasoning. You don't want to force anyone to talk and inadvertently or on purpose incriminate themselves. That's not the legal system. It's not guilty until proven innocent. It's the other way around. Even though people seem to be putting in a lot of effort these days to make it guilty until proven innocent. So while knowing, and it is a fact, that the jury could draw a negative inference from a defendant being silent, it's not being legally compelled, in the way that being held in contempt is. The court implied that the true purpose here of Amendment 5 privilege is not only to protect a criminal defendant from compelled self-incrimination, but also to ensure that no one is made worse off by asserting the Fifth Amendment than by not asserting it. And you shouldn't be. Silence in a courtroom, God forbid any of you ever find yourselves on the criminal side of a case like this, but if you do, you don't talk. You shouldn't have to talk. Guilt shouldn't be attached to your silence. And the idea here that taking the Fifth shouldn't lead to any penalty to hold in settings outside of criminal courtrooms as well. And it's been understood for a long while that the Fifth Amendment privilege can be asserted by any witness, and not just a defendant in a criminal trial, and by any witness in a civil trial, grand jury, legislative hearing, or other government proceeding. So anything. So in any criminal case here in the Fifth Amendment, it's been understood, those words, in any criminal case, not to refer to the type of proceeding where the privilege may be asserted, but as shorthand for the idea that a witness should not be required to give responses that could be used against him or her in a present or future criminal case. So, Miranda versus Arizona. Most of you have heard of this. Most of you have some idea what this is going to be about, but I'm almost at the 25-minute mark, so I'm just going to leave it for a part 2.